Oh, hi guys. Get ready to get pissed off. I haven't read this yet, but Liman has actually denied Tag's renewed motion for summary judgment. So let's go through this document. It's not too long. I just want to start out by saying, though, this is frustrating and disappointing, but Tag is still with Wayfarer, and it ends with this movie. And, you know, there's obviously the renewed motion for judgment on pleadings still at play, which Lively is expected to oppose tomorrow. Okay, let's just make that a bit bigger. Okay. Defendant Tag renews its motion for summary judgment as to the only claim remaining against it, aiding and abetting retaliation in violation of California's Fair Employment and Housing Act. Sorry, I'm stuck in a mint. I needed a mint to chill me out. Yeah. Aiding and abetting retaliation in violation of FEHA following the court's opinion and order of April 2nd, 2026, which denied Tag's initial motion for summary judgment with respect to this issue without prejudice. Plaintiff Blake Lively has filed or filed? I think it's supposed to be filed. A memorandum of law in opposition to the motion, and Tag has moved for leave to file a reply brief, which he did allow. For the following reasons, the motion for summary judgment is denied. The court presumes familiarity with the issues and facts in this case as outlined in the court's prior opinion and order. In brief, Lively alleges that she was sexually harassed on the set of It Ends With Us, and that Wayfarer Studios and It Ends With Us movie, two entities responsible for producing the film, retaliated against her for complaining about that harassment by launching a coordinated smear campaign to destroy her reputation. Lively alleges that Wayfarer and It Ends With Us movie hired Tag, a crisis communications firm, to assist them with the smear campaign. Specifically, she contends that Tag and its founder, Melissa Nathan, planted false narratives online and in traditional media outlets, portraying Lively as, among other things, a bully and a mean girl, and that they worked with others, including crisis communications specialist Jed Wallace and his firm, Street Relations, to amplify negative content about Lively online in an attempt to bury her for engaging in protected activity. On November 12, 2025, Wayfarer, Ends With Us movie, Tag, Nathan, and their co-defendants, Justin Baldoni, Jamie Heath, Steve Sauritz, and Jennifer Abel, moved for summary judgment on all claims. The Wayfarer parties also filed a motion for judgment on the pleadings. In its opinion and order addressing these motions, the court denied Wayfarer and It Ends With Us movie's motion for summary judgment with respect to Lively's retaliation claim under FEHA, finding that there existed genuine issues of material fact with respect to whether Lively engaged in a protected activity and was subjected to an adverse employment action that was substantially motivated by that activity. Of particular note, the Wayfarer parties argued in their briefing that Lively suffered no employment-related adverse action as required under FEHA, because no aspect of her employment changed for the worse after she engaged in her purported protected activity. That is, the Wayfarer parties asserted that because Lively was not demoted, sidelined, or paid less following any protected activity, she suffered no adverse employment action in any traditional sense, and she had no claim under FEHA. The court rejected the Wayfarer parties' interpretation of FEHA as unduly narrow. The court noted that FEHA covers not only employment actions that are reasonably likely to adversely and materially affect an employee's job performance, but also the employee's opportunity for advancement in his or her career. Yeah, and I would, if I was Wayfarer, I would have argued, well, she got her PGA, so her career was advanced. You know, she managed to command, even more money doing another simple favor. Her career advanced. I don't think they kind of labored that point enough. I think they made fleeting references to it, but they fixated on the fact that, she hadn't been demoted, etc., rather than well, hold on, since this, as a result of this, she got a PGA mark, which is a coveted award, coveted, accomplishment. And, she managed to command even more money for another simple favor, her highest salary for a film to date. The court further explained that retaliation claims are inherently fact-specific, and the impact of an employer's action in a particular case must be evaluated in context, considering the unique circumstances of the affected employee as well as the workplace context of the claim. Given the particular circumstances of Lively's profession, including the industry's heavy emphasis on personal and professional marketability, the court found that there were triable issues with respect to whether the Wayfarer parties took action that impermissibly and materially altered Lively's opportunity for advancement in her career by taking affirmative steps aimed not at undermining her credibility but at damaging her professional reputation and livelihood. At the same time, the court granted Nathan and Abel's motion for summary judgment with respect to aiding and abetting retaliation under FEHA. In doing so, the court relied on two California Supreme Court decisions, Reno and Jones, which stand for the proposition that there can be no aiding and abetting liability for individual non-employers acting in their capacity as agents for an employer. Aiding and abetting liability instead applies to third parties such as customers or suppliers who induce or coerce conduct prohibited under FEHA. This limitation under FEHA on aiding and abetting liability exists because FEHA only covers employers with 5 or more employees, and it would be inconceivable that small employers were shielded from FEHA claims while individual supervisors were not. Furthermore, the concept of aiding and abetting involves two separate persons, one helping the other, and because a corporation can act only through its individual employees, it would be odd to say that an employee who exercises delegated personnel management authority is aiding and abetting his or her employer in managing personnel. The court held that because Nathan and Abel were hired by Wayfarer and Ainsworth's movie to perform services on their behalf as their agents, and were, for all intents and purposes, individual employees carrying out alleged adverse employment actions at the direction of their employer, liability attached against the employer, Wayfarer and Ainsworth's movie, rather than the individuals Nathan and Abel. And I think the bit that Judge Liman has missed there, is completely overlooked, which is annoying me, is Abel was not hired by Wayfarer or Ainsworth's movie. Jones Works was hired, Stephanie Jones's company, and Abel was put in charge by Stephanie Jones of Wayfarer and Baldoni's account. So Abel, unlike, Wayfarer, yes, they contracted Tag and Street, who were companies owned by Nathan and Wallace, respectively. And I can understand that, but Liman is completely wrong to say, well, Nathan and Abel were effectively hired by Wayfarer and It Ends With Us movie. I'm not happy with that at all. That's completely wrong. And it's not the legal position either. Because, Jen Abel had been working on the account for quite a long time, long before the film, before Lively came on the scene. Because Baldoni and Wayfarer had been having their PR, handled by Jones Works for a long time. It sounds a bit, like, is it, potato, potato, but in law, these details are actually important, and I'm not happy. I'm already not happy with this order because of that. Um, the court added that while Nathan and Abel were not liable for aiding and abetting retaliation under FEHA, a different conclusion might be warranted with respect to TAG, as the California Supreme Court has held that an employer's business entity agents can be held directly liable under the FEHA for employment discrimination in appropriate circumstances when the business entity agent has at least 5 employees and carries out FEHA-regulated activities on behalf of an employer. Because business entities with 5 or more employees acting as agents for employers can be held directly liable under FEHA, the court noted that it stood to reason that these entities might also be held indirectly liable under an aid and abetting theory. The parties, however, had not specifically addressed the issue of business entity liability, direct or indirect, in their briefing. For example, neither party offered any argument or evidence regarding the number of TAG's employees, and in Raines, the California Supreme Court expressly reserved decision on the applicability of aiding and abetting liability under FEHA to business entity agents. The court, therefore, also reserved judgment on the question. That brings the court to the present motion, in which TAG renews its arguments that it cannot be held liable for aiding and abetting retaliation under FEHA. So now he's going to get into his reasons for denying the motion. TAG's renewed motion for summary judgment is straightforward. It does not turn on the intricacies or nuances of direct versus indirect liability under California law, whether TAG is a business entity with 5 or more employees, or whether Lively has provided sufficient evidence regarding the common law elements of aiding and abetting liability. The motion instead contends that TAG cannot be held liable as a business entity agent under Raines, and that because California courts treat issues of direct and indirect liability similarly under FEHA, TAG also cannot be held indirectly liable as an aider and abetter. In other words, TAG contends that direct and indirect liability under FEHA are overlapping in this context, and it disputes its direct liability, thereby disputing its indirect liability. TAG offers one primary reason why it cannot be held directly liable under FEHA, as interpreted by the California Supreme Court in Raines. TAG asserts that business entity agents can only be directly liable for engaging in FEHA-regulated activities on behalf of an employer, and TAG's public relations activities were not FEHA-regulated. The relevant language from Raines, which TAG cites for this proposition, reads, "Although the question presented in this case does not require that we go further and attempt to identify the specific scenarios in which a business entity agent will be subject to liability under the FEHA, we recognize as a necessary minimum that, consistent with the FEHA's language and purpose, a business entity agent can bear direct FEHA liability only when it carries out FEHA-regulated activities on behalf of an employer." TAG's motion must be denied. The court has already rejected its central premise, namely that the activities at issue in this case necessarily fall outside FEHA's scope and are therefore unregulated by the statute. To recap, Wayfair and Ainsworth's Movie argued in their motions for summary judgment and judgment on the pleadings that the activities alleged by Lively were not FEHA regulated because they did not implicate traditional employment actions such as hiring, firing, or altering an employee's pay. The court explained that FEHA is not so limited. So what he's saying here is TAG made the same argument that the court has already rejected with Ainsworth's Movie and Wayfarer. And I don't disagree with that, actually. Now I'm kind of reading it in being kind of worded in this way. Yeah, actually, I can see it. I can see what he means. I don't like it. But what he's saying is, look, you could have argued a bit more, like how many employees has TAG got? Are they FEHA regulated? Do they perform FEHA regulated activities? Do they have the 5 employees? Because it's not certain, and what he's saying is there are details about tag and its kind of business function that have not been argued by either entity, by either party in this case. And I think he was kind of inviting, hey, look, tell us a bit more about tag. And they didn't do that. The California Supreme Court has instructed courts to analyze FEHA retaliation claims in context and based on the unique circumstances of the affected employee, as well as the workplace context of the claim, interpreting the statute broadly to further its fundamental and anti-discrimination purposes. The California Supreme Court has further indicated that FEHA protects an employee against unlawful discrimination with respect not only to so-called ultimate employment actions such as termination or demotion, but also the entire spectrum of employment actions that are reasonably likely to adversely and materially affect an employee's job performance or opportunity for advancement in his or her career. California law therefore eschews any strict requirements of traditional or ultimate adverse employment actions, instead adopting a more flexible, context-specific approach, including for actions which impair only future employment prospects. Based on this standard, the court found that Liability had provided sufficient evidence at the summary judgment stage regarding actions which might have been taken to limit her opportunities for advancement in her career. The judge is not saying that actions were taken. He's saying there's a fact issue here, but wait for Q Lively's Instagram post, which will get community noted. The court accordingly denied Wayfarer and Endless Movies motions with respect to Lively's claims for retaliation under FEHA. The exact same activities which might support liability against Wayfarer and Endless Movie are the ones that TAG is alleged to have engaged in. In its order and in its opinion and order, the court outlined certain conduct that could be construed as directed not at Lively's allegations not at Lively's allegations and at undermining their credibility, but as an attack on her professional reputation and livelihood. TAG has not specifically attempted to distance itself from the activities which the court found presented a genuine issue for trial. Thus, to the extent Wayfarer and Endless Movie might be liable under FEHA for engaging in retaliation, TAG's argument now that its participation in those very same activities was not FEHA regulated lacks merit. If the activities that form the basis of Lively's retaliation claim were not at least potentially regulated by FEHA, the court would have granted Wayfarer and Endless Movies motion for summary judgment and judgment on the pleadings. I can see what he means. I can see it. TAG's alternative arguments for summary judgment likewise are without merit. For instance, TAG suggests that FEHA prohibits misconduct only by employers, not third parties. TAG states that FEHA prohibits employers from aiding and abetting third parties, not the other way around. For support, TAG cites dicta from Redenst. In that case, in the course of deciding that FEHA would not support a claim against 2 individuals who were officers of the defendant non-profit corporation, the court stated in passing that FEHA's aiding and abetting provision is meant to prohibit employers from aiding and abetting third parties, such as customers or suppliers, not from aiding and abetting themselves. This statement from Redence cannot bear the weight that TAG puts on it. For one, the statement was dicta. The court's decision was based on the conclusion that under California law, discrimination and retaliation causes of action do not create individual liability for supervisors or other employees of the offending employer or employment agency, either directly or by an aiding and abetting theory. That is, the decision turned on the proposition upon which the court dismissed Abel and Nathan from this case, not on the proposition that only employers can aid and abet retaliation. For another, Redence cites the California Supreme Court's decision in Reno for support, but Reno states that FEHA's aiding and abetting language makes it unlawful, for example, for third parties such as customers or suppliers to induce or coerce prohibited discrimination or harassment. As such, to the extent Redence could be read to say that a third party cannot be liable for aiding and abetting an employer's discrimination, that is an inaccurate statement of law. Indeed, it makes little sense to say that FEHA's aiding and abetting provision is intended only to prevent employers from aiding and abetting employment discrimination committed by third parties, such as customers or suppliers, rather than preventing third parties from aiding and abetting employment discrimination committed by employers. A person is liable for aiding and abetting under FEHA if the aider and abetter knows that another's conduct violates FEHA and gives substantial assistance or encouragement to the principal to violate the statute. In other words, there must be some underlying substantive violation, employment discrimination, committed by someone else that the aider and abettor knows about and encourages or assists. In the absence of a principal violation, there can be no aiding and abetting liability. But if only employers could be liable for aiding and abetting, there would be little need for the aiding and abetting provision. The employer who engages in discrimination or retaliation is already liable as a principal. The aiding and abetting provision is instead most naturally read, as Reno expressly indicates, to prohibit third parties who are not otherwise covered by the statute from encouraging or assisting employment discrimination. California cases confirm that FEHA's aiding and abetting provision covers non-employer third parties. Acknowledging this case law, TAG asserts in its reply brief that even if third parties might be liable for aiding and abetting under FEHA in certain circumstances, they must still have performed some employment-related function on behalf of an employer. As explained above, there is a triable issue here with respect to whether TAG engaged in an employment-related function on Wayfarer and Endless Movies' behalf by subjecting Lively to adverse treatment that was reasonably likely to impair her prospects for advancement in her career. TAG's purported employment-related function rule therefore does little to help it in this case. Additionally, there is no reason to doubt that any such rule exists. To the extent TAG suggests that a third party must be acting as an employer's agent by carrying out some employment-related function in order for there to be aiding and abetting liability, that is really just another way of arguing that the third party must be an employer. FEHA defines employer as including any person acting as an agent of an employer, directly or indirectly. Because the statute equates an employer's agents with the employer itself, requiring some sort of agency relationship for aiding and abetting liability would effectively cabin such liability to employers, which, as indicated above, California courts reject. Case law further undermines TAG's employment-related function rule for aiding and abetting liability. For one, Reno explains that third parties, such as customers or suppliers, may be liable for aiding and abetting substantive FEHA violations, and it is unclear how or why a customer would engage in an employment-related activity on behalf of an employer. Moreover, in addressing aiding and abetting liability, California courts have assumed that third parties need not engage in an employment-related activity on behalf of an employer for liability to attach. For example, in Smith, the California Court of Appeals analyzed whether a vendor would be liable for aiding and abetting FEHA retaliation by making offensive remarks during a presentation in which the vendor promoted its own product to the employer's employees, including the plaintiff. The court rejected the claim on the grounds that the plaintiff had failed to establish the common law elements of aiding and abetting liability. But nowhere did it suggest that because the vendor had not engaged in an employment-related activity, there could be no liability. even though it seems clear that promoting a product as an outside vendor does not constitute an employment-related function, as TAG narrowly understands that phrase. Ultimately, this court, like the California Supreme Court in Reigns, need not express any definitive view regarding the scope of a business entity's agent's possible liability under the FEHA's aider and abettor provision. In this motion, TAG has argued that there can be no aiding and abetting liability against it because the conduct in which it engaged is not FEHA regulated, and the court has rejected that view. Motion for summary judgment is denied. So yeah, that is annoying, but actually I can actually see what he means, and yeah, I do think he's actually right. Well, he makes a good argument anyway. But obviously I'm just going back up because this has utterly annoyed me now. But that is a problem. To suggest that Abel was hired by Wayfarer to perform services when she was not. And in fact, Liman in the Jones case quite literally has an indemnity cause of action in front of him, where Jen Abel is, basically seeking a ruling that if she is found liable, which she's now not going to be, but if she was found liable and had to pay damages to Liability, etc., that, as she was working, she was in her capacity as an employer. She was in her capacity as an employee for Jones Works. Then, she wanted a ruling which basically affirmed that Jones Works would indemnify her. So, and given that Liman is, he's obviously aware of the circumstances of the case. He's obviously aware of the Jones Abel docket because, that's supervised, that's overseen by him too. But this details matter, right? And I think he is wrong to say that Abel was hired by Wayfarer and Enzelus to perform services when she was not. Jones Works were. Abel just happened to be the employee of Jones Works who was assigned to deal with Baldoni and Wayfarer's accounts. And that includes and encompasses the quote-unquote, all the time that Lively says that she was sexually harassed, all the times that she participated in protected activity that she claims is protected activity, like the January 4th meeting, the return to work protections, extortion document. It also includes the premiere and, the start of the time period where the alleged smear campaign apparently began. So even if you was to say, well, yeah, but from the end of August, Jen Abel was not hired by, she was not, from the end of August, Jen Abel was technically hired by Baldoni and Heath and Wayfarer. All the time that passed before then, she was actually a Jones Works employee, and these details are kind of matter. They matter here. Let me know what you think. But yeah, so he has denied that motion for summary judgment, and I believe, I'm just double checking here. I mean, it's denied. That will mean that it is denied with prejudice, so he's not invited her to refile. Don't forget, though, as I said at the start, there is still the motion for judgment on the pleadings, which Lively, we're expecting her opposition tomorrow, so we'll see what she says to that.